Dear students, subscribers and the viewers, welcome to the IAS Mentor. The larger objective of this particular channel is to provide quality guidance to the students preparing for UPSC IAS examination. And in line with the larger objective, we are also involved in providing lot of quality content to the students through this particular channel. And the first of such initiative was to provide quality content on the subject Indian polity, and for which we already started a series. We have already done a number of lectures, and this would be lecture number 16 in the series of the Indian polity, where till this point of time, if you see the last 15 lectures, we have covered the very basics of the Indian polity. And in fact, we also covered the part 1 of the Indian Constitution, that is the Union and its territories. We have covered Article 1, 2, 3 and 4. So in today's lecture, we are going to begin a new part in the Indian Constitution, that is part 2 of the Indian Constitution, where we'll basically deal with the concept of citizenship as to what the Constitution says about the citizenship of India. So that we'll do elaborately as we'll proceed from now on. But if you see, the objective of this particular series is not only to deal with the Indian Constitution, but we'll also cover major books which is relevant for UPSC preparation, especially the books like LAXMIKANTH will be covered during the course. And this series is likely to go on for next 3 to 4 months. So we'll try to cover the entire subject Indian polity very comprehensively. Alright. So with that introduction, we'll get into the next part of the Indian Constitution, that is the part 2 of the Indian Constitution, which basically deals with what is called as citizenship. So the first question that we have to ask ourselves is, what is this concept of citizenship and what does this mean? So basically, what is this concept of citizenship? Now, citizenship is a legal status that is conferred upon the state upon its citizens. So there is an established state and there are subjects of that particular state. And the relationship between the state and the subjects, probably the people of that particular country, is defined by what is called as citizenship. So I would say citizenship is nothing but a legal status a state conferred upon its people. And by conferring this legal status, that is the status of citizenship, the state is empowering the people of that particular country, or I would say citizens of that particular country, to exercise and enjoy full civil and political rights. And in return, the state would expect the citizens to owe allegiance towards the state, to be loyal towards the state. So that is basically what is called as citizenship. So what does it mean when I say full civil and political rights? When I say full civil and political rights, say for example, the civil rights would include the right to freedom of speech and expression. The civil rights would include right to freedom of religion. So these are all rights which are civil in nature. On the other hand, there are certain rights which are political in character. Say for example, right to occupy public office, right to contest election for public office, right to vote in the election. So probably these are the rights which are political in character. So as a citizen of India, once you are conferred the citizenship of India, you will have full civil and political rights that is guaranteed by the Constitution, or even outside the Constitution there can be lot of rights, but you are entitled to exercise all the civil and political rights that is guaranteed. So that's basically what is called as the concept of citizenship. And in return, what the state would expect from you is that you owe your loyalty towards the state. You always be loyal towards the state. So that is what is the expectation. So does it mean that the Constitution or the laws in India does not confer any right upon the aliens? So before we answer this particular question, we'll have to understand as to who is an alien. So an alien is someone who is not a citizen. In fact, try to understand these two terms are mutually exclusive, or these two concepts are mutually exclusive. Anyone who's an alien is not a citizen of India. Anyone who's a citizen of India is not an alien. Now try to understand this very clearly. So aliens are those who may be a citizen of other country, but they are not a citizen of India, but still they may stay in India, or they may come to India for a short period of time and then they may return back to their respective country. Whatever be it, they would be declared to be what is called as an alien. So the aliens in India, do they not exercise any rights which is guaranteed by the Constitution? That is not true. The aliens can also exercise certain rights. Say for example, the aliens in India also exercise what is called as right to equality under the constitution. The aliens in India also exercise what is called as right to freedom of religion. But while the aliens in India may exercise some of the rights or even most of the rights, but they shall not exercise or they may not exercise the full rights that is exercised by what is called as citizens. There are certain restrictions upon what type of rights the aliens can exercise in India. Say for example, the aliens in India may not be able to exercise what is called as most of the political rights. They will not have right to public employment, or they may not have right to contest election. They may not have the right to vote in the elections. So the basic understanding that you should have is that while both the citizens and the aliens may exercise the rights, but while the citizens will exercise the full rights that is guaranteed by the constitution, that is guaranteed by the ordinary laws of the land. Whereas the aliens may exercise some of the rights, but definitely not full rights that may be exercised by the citizens. So basically, this is a way the state makes some kind of, I would say, discrimination between a citizen and an alien, and thereby it is giving more importance to its citizens. And in return, it expects the allegiance or the loyalty from the citizens towards the state. So this is basically what is called as a concept of citizenship, and in fact every country or every state has its own provisions as per their respective constitution to identify their citizens. And in fact, the Constituent Assembly of India, when they were drafting the Constitution of India, they also had a broader discussion as to how to identify the citizen of India. And ultimately, after a lot of debate, in fact, the provisions of citizenship is one area where there was a lot of debate that has happened in the Constituent Assembly. You know that the Constituent Assembly is a body that was established to draft the Constitution of India. And the debates that has happened in the Constituent Assembly that ultimately decided as to who shall be the citizen of India at the commencement of the Constitution. That means, try to understand, the Constitution had some provisions based on the debates in the Constituent Assembly, and those provisions said that on 26 January 1950, that is the day on which the Constitution comes into force, there are certain categories of people who would automatically be considered to be the citizen of India. So that is what basically you have to understand. So if you look into part 2 of the Constitution gives certain criterias, or there are certain articles in part 2 of the Constitution which basically deals from article 5 to article 11. So these are the articles that we are going to discuss as we will continue with the concept of citizenship, article 5 to article 11. So if you read these articles one by one, we will try to understand that there are some provisions which is given in some of these articles which says that anyone who will satisfy these conditions at the commencement of the Constitution, that is on 26 January 1950, they would automatically be considered to be the citizen of India. They don't have to do anything. Merely they have to satisfy the condition given in these articles, which we will subsequently understand. The moment they will satisfy these conditions, they would be deemed to be the citizen of India when at the commencement of the Constitution. But what about the concept of citizenship subsequent to the commencement of the Constitution? That is, after 26 January 1950, who will be considered to be the citizen of India, or what is the basis on which the citizen shall be identified by the state? For which the Constitution is saying that at the commencement of the Constitution, that is on 26 January 1950, to determine the citizenship, we are providing certain criteria in the Constitution. And what are those articles that deals with the criteria to determine the citizen at the commencement of the Constitution? That is article 5 to article 8. So this is very, very important. So from article 5 to article 8, there are certain criteria that is given in the Constitution, that if they are satisfying these conditions from article 5 to article 8 of the Constitution, they would be deemed to be the citizen at the commencement of the Constitution. When I say at the commencement of the Constitution, that is on 26 January 1950. If they satisfy the conditions given here, they would be automatically deemed to be the citizen of India. But however, who would be the citizen subsequent to the commencement after 26 January 1950? For which the Constitution does not give an elaborate criteria, but rather the Constitution says after 26 January 1950, if there's a question that arises somebody is a citizen of India or not, then the law shall be made by the parliament, and by that law the citizenship shall be determined. That means after 26 January 1950, who shall have the power to determine the citizenship in India? It shall be established by a way of a law that is made by the parliament, and to that extent, the parliament is given power by the constitution to determine the citizenship subsequent to the commencement of the constitution. So two things that you have to basically understand when it comes to the concept of citizenship. First thing is, the constitution is making it very clear as to who would be the citizen at the commencement of the constitution. At the commencement, who are the citizens? Whoever is satisfying the criteria in article 5, 6, 7 and 8. So we'll go and try to understand as to what are the criteria which is given in article 5, 6, 7 and 8. But however, if a question arises, who would be the citizen of India after the commencement of the constitution? After the commencement of the constitution also, citizenship will be granted. In fact, all of us, maybe most of us, including me and most of the students who are viewing this particular lecture, I'm sure that we all become the citizen of India after the commencement of the constitution, because I don't think none of us, if some of the viewers are there who born before 1950, then maybe their citizenship is determined based on what is given in article 5, 6, 7 and 8. But most of us here, or I would say rather with the limited information I have, or with the limited assumption that I got, that most of us are born after 26 January 1950. So our citizenship is determined by what? Based on the law that is made by the parliament. And such a law that is made by the parliament is nothing but what is called as Citizenship Act 1955. So to put it in a very simple way, so till this point of time, what is understanding you should have? You should very clearly know as to what is this concept of citizenship. How a citizen is different from that of an alien. And what the constitution talks about when it comes to citizenship. There are two types of provisions in the constitution. In part 2, that is one that deals with who are deemed to be the citizen or who are automatically considered to be the citizen at the commencement, that is on 26 January 1950. And subsequent to the commencement, who would be determined or who would be considered to be the citizen, that is to be determined by a way of a law that is made by the parliament. And which article in the constitution is giving this power to the parliament to make a law is article 11 of the constitution. So article 5 to article 8 deals with those provisions as to who will be deemed to be the citizen at the commencement of the constitution, that is on 26 January 1950. Whereas article 11 is giving the power to the parliament to make an ordinary law, and by that law it will give the provisions, and by that law, based on the provisions, the citizenship will be determined subsequent to the commencement of the constitution. And so article 11 is giving this power to the parliament, and parliament is the only authority to determine the citizenship subsequent to the commencement of the constitution. And accordingly, they have enacted what is called as a Citizenship Act 1955. So today the law based on which our citizenship is determined is based on Citizenship Act 1955, especially those after the commencement of the constitution. And of course, this is just a preliminary understanding you should have before we get into the topic of citizenship. In fact, there are a lot of other provisions that you will have to remember, but this is the basic idea probably you should have in the first place. All right. So with that, we'll get into the first article that is given in citizenship is article 5. Now keep this as a general rule that article 5 to article 8 deals with what? Article 5 to article 8 provides criterias. Every article does provide a criteria. But however, try to understand right from article 5 to article 8, every criteria that is given deals with as to who would be deemed to be the citizen at the commencement of the constitution. That means if the people are satisfying any of these conditions at the commencement of the constitution, they would be considered to be the citizen at the commencement of the constitution. So now let us try to understand what article 5 talks about. Article 5 is saying anybody who is domiciled in India. So that's a primary criteria. So try to understand. Anyone who is domiciled in India, so this is the first criteria. Anyone who is domiciled in India plus along with domicile in India if they satisfy any of these three conditions. So along with the domicile, this condition or this condition. So of the three conditions, they should satisfy any of the one condition. If they satisfy any of these one condition along with being a domicile at the commencement of the constitution, then they are automatically deemed to be the citizen of India on 26th January 1950. Nothing else they have to do. So this is what Article 5 of the Constitution is saying. But however, we'll have to break down these things one by one. So first we have to understand as to what is domicile. Now what do you understand by domicile? So domicile is equivalent to residence plus intention of an individual to make that place as his permanent home. So domicile is not merely equivalent to that of what is called as residence. So domicile means residence plus an intention of an individual to make that place as a permanent home. So now you can ask me that how the state will know about the intention of an individual. The state can come to know about the intention of an individual based on the conduct of the individual. Say for example, how long the individual has stayed in that particular place, or probably what are the kind of property that the individual has in that particular place. So based on all these things, the state may come to a conclusion as this individual is not only residing in this particular place, but the individual is also having an intention to make this place as his permanent home. So if the state is convinced that the individual is domiciled in India at the commencement of the constitution, but that is not sufficient enough, that's a major criteria. But in addition to domicile, there should satisfy all these things. So for example, if he is born in India at the commencement of the constitution, that means before the commencement of the constitution he is already born in India, and then he is also domiciled in India, then he is already a citizen of India at the commencement of constitution, or the citizenship is automatically conferred upon him at the commencement of the constitution. Okay, he is not born in India, the individual himself in question whose citizenship is in question is not born in India, but either of his parents were born in India, that is also sufficient enough. So for example, individual X whose citizenship is in question at the commencement of the constitution, he was not born in India, but any of his parents were born in India, but he is domiciled in India, then also he is eligible to be a citizen of India. Okay, he is not born in India, either of his parents are also not born in India, but if he has resided in India for a period of 5 years before the commencement of the constitution, then also he is eligible to be a citizen of India at the commencement of the constitution. That means 26th January 1950 the constitution came into force. So before that he has stayed in India at least for a period of 5 years. And then he is also domiciled. He also had an intention to make India as a permanent home. If these conditions are established, then he is automatically deemed to be the citizen of India at the commencement of the constitution. So those people who are satisfying this particular criteria will automatically considered to be the citizen of India at the commencement of the constitution. So that is what basically Article 5 talks about. So basically Article 5 talks about the criteria for domicile, and whoever is domicile along with these criteria, they are conferred the citizenship of India at the commencement of the constitution, that is on 26th January 1950. So while Article 5 is about domicile, whereas Article 6 is talking about a separate criteria, and these people will also be eligible to become a citizen of India at the commencement of the constitution. So we have seen Article 5 is about domicile. So let us try to understand as to what Article 6 talks about. Article 6 talks about persons who have migrated from Pakistan to India. So these two words are important. Persons who migrated from where? Pakistan to India. So now try to understand, 1947 there was independence, and 15th August 1947 two separate states was created, India and Pakistan. So 15th August 1947 probably partition, India, Pakistan was created, and there were many people who migrated from India to Pakistan. There are many people who then migrated from Pakistan to India also at that point of time. So because of the partition, there was free flow of migration, and because of the communal tensions, all these things happened. Now what is Article 6 is talking about? Try to understand. Although the partition happened in August 1947, but the Constitution of India came into force only on 26th January 1950, right? So you'll have to understand these things. Now, even after the partition, even after independence, India did not have a constitution. The Constituent Assembly was only drafting the constitution. So when they were drafting the constitution, they had discussion about this provision also. Okay, Article 5 is talking about those people who are domiciled in India, all right. But what about people who are migrated from Pakistan to India? 1947, 15th August 1947, partition. So there are people in India, there are people who have gone to Pakistan. By partition, they have gone to Pakistan. It was not their wish to be part of Pakistan. Try to understand, by partition, they have gone to Pakistan. Now, those who will understand as to how the partition has happened, although this is completely not related to polity, but this idea is also very important. So, to understand this particular provision, you should also have a background as to how the partition has happened. In fact, the way the partition was designed by the Britishers between India and Pakistan is not on the wish of the people. They basically divided, certain parts will go to Pakistan depending upon any province at that point of time which had Muslim majority will become part of Pakistan. Any province which will have Hindus as the majority will become part of India. And any province, there were certain provinces which had equal Hindus and equal Muslims, and they were divided equally between India and Pakistan. So it is by this way the partition has happened. So there were many people who become part of Pakistan just because of this design. It is not that they wanted to be part of Pakistan. There are many Hindus probably who went to Pakistan because they were minorities in the Muslim majority provinces. So what has happened in the Constituent Assembly is, so the Constituent Assembly thought not necessarily only for the Hindus, but also the Muslims who wanted to come back. There were certain Muslims who also wanted to be part of India, probably. So why this provision was designed by the Constituent Assembly is, although the partition happened on 15th August 1947, but the Constituent Assembly was still drafting the constitution. So they decided that on 26th January 1950, there were certain categories of people who had migrated from Pakistan to India. That means on 15th August 1947, they become part of Pakistan. But before the commencement of the constitution, they would have migrated from Pakistan to India. That is a possibility. So Pakistan is here, let us assume India is here. So although the partition happened on 15th August 1947, it might be possible that they can migrate from Pakistan to India. And if they have migrated from Pakistan to India, will they be eligible to become a citizen of India at the commencement of the constitution? Yes. They should also be given an option, or they should also be eligible to become the citizen of India at the commencement of the constitution, and that is what is governed under Article 6 of the constitution. But of course, yes, for which they have to satisfy certain conditions. That is very important. So for example, let us assume X is an individual, by partition has gone to Pakistan. Assume by partition has gone to Pakistan, and then X has migrated from Pakistan to India, and when he has migrated from Pakistan to India, he has migrated before July 19, 1948. So this cutoff date is fixed in the constitution. Suppose let us assume that X has migrated before July 19, 1948, and he has to satisfy certain other conditions also. So what are the other conditions he has to satisfy? That if he or his parents or grandparents was born in undivided India, and then he has also migrated from Pakistan to India before July 19, 1948. That means what? Suppose by partition, if X has gone to Pakistan, and then X wanted to migrate to India, and if X has migrated before July 19, 1948, because after partition, there were a number of days, but if he has migrated before July 19, 1948, and also provided that he himself or his parents or his grandparents were born in the undivided India, that is the territory of India as per the Government of India Act 1935. That's basically anywhere in Pakistan or in India, it does not matter. So he himself or his parents or grandparents were born in the territory of undivided India, and also by partition he has gone to Pakistan, but later he has migrated from Pakistan to India before July 19, 1948. So if he has migrated before July 19, 1948, so the cutoff date is what? Before July 19, 1948. 1948. So if the migration is before July 19, 1948, then he is automatically deemed to be the citizen of India at the commencement of the constitution, provided that after such migration, he is ordinarily resident in India. So if he is ordinarily resident in India at the commencement of the constitution, he is automatically deemed to be the citizen. So let me just clarify all those things. So what is Article 6 is talking about? Article 6 wanted to give opportunity for those people who have migrated from Pakistan to India. So why an opportunity has to be given to these people? Because by partition, certain people have gone to Pakistan. It was maybe not their intention. By the design, they have gone to Pakistan. And if these people wanted to migrate back again to India, should they be given the citizenship? Yes. The Constituent Assembly thought that they should also be given the citizenship, provided that those people who migrated from Pakistan to India, either they themselves or their parents or their grandparents were first born in the undivided India. That is according to the territory of British India as per the Government of India Act 1935. If this condition is satisfied, then it has to be seen when they have migrated. If they migrated before July 19, 1948, that is between 15th August 1947 and July 19, 1948. If they migrated between this period and they have satisfied the first condition and they have migrated between this period, then after such migration, if they are ordinarily resident in India, that means they should have stayed in India. If they satisfy these conditions, then at the commencement of the Constitution, that is on 26 January 1950, they are all automatically deemed to be the citizen of India. So that is what Article 6 is. So Article 6 is basically dealing with those categories of people who are migrated from where? Who are migrated from Pakistan to India. But migrated when? They migrated before July 19, 1948. Okay, now let us assume that there are certain categories of people who migrated on or after July 19, 1948. They are satisfying this particular condition, okay, that either they or their parents or grandparents were born in the undivided India. But they failed to migrate before July 19, 1948. And if they wanted to migrate or if they migrated on or after 1948, then there are additional conditions. So if they are migrating on or after 1948, first of all, they can migrate only by what is called as a permit system. That means, let us try to understand this way. Somebody who wanted to migrate from Pakistan to India before July 19, 1948, it was a free open system. That means they don't have to take any special permission. They can migrate and they can come to India. But whereas somebody who migrates on or after July 19, 1948, the Government of India introduced what is called as a permit system. And what is this permit system? Say, let us assume for easy understanding, a special pass that they have to get. And who is authority to provide this special pass? That will be decided by the Government of India, and that was the Indian High Commissioner in Karachi. So the Indian Embassy was there in Karachi. So the High Commissioner of India in Karachi has to issue this permit for the people to migrate from Pakistan to India. First of all, they have to get this pass. And if they get this pass and they enter into India, then they have to come and they have to register themselves with an Indian authority. Then they have to make a registration with an Indian authority. So whoever is the officer appointed by the Government of India, with them they have to register. And to make this registration, they should have stayed minimum 6 months in India before the commencement of the Constitution. That means, try to understand. For those people who have migrated on or after July 19, 1948. So first of all, to enter into India from Pakistan, they have to get a permit system. And once they get this permit system, they enter into India. And then they come and stay in India. How long they should minimum stay in India? They should have stayed in India minimum for a period of 6 months. And if they have stayed in India minimum for a period of 6 months, when? Before the commencement of the Constitution, that is before 26 January 1950. If they have stayed in India minimum for a period of 6 months, then they can make an application for registration with a concerned government authority, the officer who is appointed by the Government of India to become an Indian citizen. So they have migrated on or after July 19, 1948. And for which they have taken a permit, entered into India. They stayed in India for a period of 6 months before the commencement of the Constitution. Then they make an application to register themselves as a citizen of India. So if they complete all these process, then they will also be deemed to be the citizen of India at the commencement of the Constitution. So basically, Article 6 is what? Article 6 is talking about those categories of people who have migrated from Pakistan to India. The only difference is that in both the categories, they themselves or their parents or their grandparents should be born in the territory of undivided India according to the Government of India Act 1935. But however, there is a procedural difference depending upon when they are migrating from Pakistan to India. Before July 19, 1948 or on or after July 19, 1948. The procedure on or after 1948 is little complex, whereas before that it is easier. Now, why the procedure to become an Indian citizen on or after July 19, 1948 was complex? Because the government of India was of the idea, or the members of the Constituent Assembly was of the idea, the partition happened suddenly, and there were many people who wanted to be part of India but has gone to Pakistan. So, a period of easy movement of people, or a period should be allowed for easy migration from Pakistan to India. And so they have given some duration of time where the migration from Pakistan to India was quite easier. And by July 19, 1948, the government of India thought that the migration has stabilized. That means whoever wanted to migrate, they have already migrated. So people who had a desire to migrate from Pakistan to India, and that window of opportunity was sufficient enough, and they have migrated. But from now on, that is on or after July 19, 1948, still we are not restricting the migration, but probably we are regulating the migration. So from now on, if anybody has to migrate, you take the permission and then you can migrate. So that's the reason as to why they fixed this particular date as July 19, 1948. So the idea is, by the time, in the opinion of the government and in the opinion of the Constituent Assembly, the migration is stabilized. So this is basically what you'll have to understand. But anyways, to put it in a very simple way, what is Article 6? Article 6 is talking about those categories of people who have migrated from Pakistan to India, and therefore they are also eligible to become the citizen of India at the commencement of the Constitution. So the word at the commencement of the Constitution is what is very important. So now let us move to Article 7 of the Constitution. So for most of the students, both Article 6 and Article 7 look similar, but they are not one and the same. So what is Article 7 of the Constitution? And before we go to Article 7, let us just quickly take a recap of what is Article 5 and Article 6. What is Article 5 of the Constitution? Article 5 of the Constitution is talking about that people who are domiciled in India with certain conditions would be deemed to be the citizen at the commencement of the Constitution. What is Article 6 of the Constitution? Article 6 of the Constitution is talking about those categories of people who have migrated from Pakistan to India. The only difference is whether they have migrated before July 19, 1948 or after, on or after July 19, 1948. But in both the cases, they have migrated from Pakistan to India. That means by partition, they have gone to Pakistan and later they have come to India. But what about Article 7 of the Constitution? Article 7 of the Constitution talks about people who have migrated from Pakistan to India. So people who have migrated from Pakistan to India, but even before they have migrated from Pakistan to India, first they have migrated from India to Pakistan. That means Article 7 is talking about those categories of people who have migrated first from India to Pakistan and later again from Pakistan to India. So those were the categories of people who are dealt under Article 7. In fact, among the citizenship provisions in the Constituent Assembly, one provision that was most debated is what is Article 7. In fact, why Article 7 was most debated? Because many members in the Constituent Assembly thought that these categories of people who have migrated from India to Pakistan and later from Pakistan to India, they should be never given an opportunity to become an Indian citizen because they have deserted India in the first place and left to Pakistan, and therefore they should not be given an opportunity. So this was the opinion that prevailed among some of the members in the Constituent Assembly. But however, the majority thought, no, we shall not always think that people who have migrated from India to Pakistan has deserted India. It may not be the factor that they migrated from India to Pakistan just because they don't like India, but maybe other situational factors, other circumstances. Maybe most of their relatives are in the side of Pakistan. Maybe their entire business is running in the side of Pakistan. So they were left with no other options but to migrate from India to Pakistan. But however, later they have changed their mind and they have returned back from Pakistan to India. So in this case, they should also be given an opportunity to become an Indian citizen. So that is what is Article 7 of the Constitution. But however, a lot of conditions you'll have to understand. So what Article 7 is saying, people who have migrated from India to Pakistan on or after 1st March 1947. So this is what is important. So after 1st March 1947. So you might think that at that point of time, there was no state of Pakistan. But why this particular date, 1st March 1947, that is after 1st March 1947, 1st March 1947 was fixed as a cutoff date by the Constituent Assembly because the communal tensions were at its peak during this point of time. And it was also quite clear that the separate state of Pakistan will also be formed. In order to address the communal tensions, the British government at that point of time has announced Pakistan will be created as a separate state. So once this announcement was made, there are many people, and they also know as to how Pakistan will be created. So based on the Muslim majority states. So there are many people who were to become part of India once a partition happens. They migrated willingly from the Indian side to the Pakistan side. So therefore, their intention was to become part of Pakistan. So anybody who was migrated before 1st March 1947 will not fall under this category. But anybody who was migrated after 1st March 1947, the Constituent Assembly assumes that you are migrating from the Indian side probably to the Pakistan side for the reason that you want to become part of Pakistan. But if you migrated before that, nobody was even aware whether the separate state of Pakistan will be created or not. But by 1st March 1947, it was clear that Pakistan as a separate state will be created. So migration after 1st March 1947 from say probably the provinces which will become part of India to the provinces which will become part of Pakistan, that means the Constituent Assembly assumes that your intention to migrate from here to there is probably that you want to be part of Pakistan. Okay, you have migrated. So you have migrated after 1st March 1947. By 15th August 1947, two separate states were created, India and Pakistan. But you have migrated, say let us assume, so this is Pakistan, so just listen to this carefully. So suppose this is assumed, this is India, so this is Pakistan. So first initially an individual migrated from here. So when he has migrated after 1st March 1947, so let us assume. So 1st March 1947 is the cutoff date. So let us assume X is an individual who has migrated from India to Pakistan after 1st March 1947. But again what he has done, he has returned. So partition happened on 15th August 1947. So once he has become part of Pakistan, X is again migrating from Pakistan to India. Suppose let us assume he is migrating on any date after 15th August 1947. Suppose let us assume he is migrating on 1st January 1948. So he is again returning back from Pakistan to India. Is he allowed to migrate from Pakistan to India? Yes, he is allowed to migrate from Pakistan to India. But however, at any point of time he wanted to migrate, it doesn't matter when he is migrating. At any point of time he is migrating after 15th August 1947, whenever he is migrating, he can migrate only with a special permit. So without a special permit, he cannot migrate. So this special permit means a special pass or a special permission is required for him to migrate from Pakistan to India. And this special permission will be given by the Indian High Commissioner in Karachi. The Indian High Commissioner in Karachi will verify the profile of this particular individual so that after that verification is done, he will be allowed to migrate to India. So the point is whenever he is migrating, he has to take that special permit. And then he enters into India with this special permit. After he enters into India with this special permit, he resides in India for a period of 6 months, minimum 6 months before the commencement of the Constitution. And if he resides in India minimum for a period of 6 months before the commencement of the Constitution, then he can make an application to register himself as the citizen of India with the government authority or with the government officer. So if he satisfies all these criteria, then he is also eligible to become the citizen of India at the commencement of the Constitution. So it is almost similar to that of what we have seen in Article 6 for the second category of people, that is those who are migrated on or after July 19, 1948. It is almost same to that. But however, the difference between Article 6 and Article 7 here is, while in Article 6, it is not talking about people who are migrated from India to Pakistan and then from Pakistan to India. Article 7 is dealing with those things. Article 6 is only people who are migrated from Pakistan to India. But there are two categories of people who migrated on before July 19, 1948. And the second category of people is on or after July 19, 1948. But Article 7 is talking about all those people who are migrated from India to Pakistan after 1st March 1947, but later returned to India. So then in that particular case, they have to follow all those things, and then they are also eligible to be a citizen of India. Is that clear to all of you? So now the last article, that is Article 8, with regard to the criteria that is given in the Constitution as to who are all eligible to be the citizen of India or deemed to be the citizen of India at the commencement. So at the commencement, there are only 4 articles that is given: Article 5, 6, 7 and 8. So whoever satisfying all these, any of these criteria, they would be deemed to be the citizen at the commencement of the Constitution. So now let us try to understand as to what is there in Article 8 of the Constitution. What is Article 8 of the Constitution? Article 8 of the Constitution is talking about those categories of people who are staying outside India. So if you see Article 5, Article 6 and Article 7, there's one thing that is common about all these articles. What is common? Irrespective of whether they are domiciled in India under Article 5, people migrated from Pakistan to India under Article 6, people who are migrated from India to Pakistan, again back from Pakistan to India under Article 7. In all these cases, at the commencement of the Constitution, if you see, they are all domiciled or they are all staying in India, they are residing in India. So that is true. And only when they are resident in India, they will be eligible to become an Indian citizen. But however, there are certain categories of people that who are residing outside India. They are not even in the territory of India at the commencement of the Constitution. Will they be eligible to become an Indian citizen at the commencement of the Constitution? Yes, they will also be eligible to become an Indian citizen at the commencement of the Constitution by virtue of what is Article 8 of the Constitution. In fact, those people are what is called as the person of Indian origin. So person of Indian origin means what? These are all categories of people who have some origin with India, but for some reason they have migrated from India and right now they are residing in some other country. Now, if you look back into the Indian history, you might know that lot of people during the British time, they migrated from India for various reasons. Somebody migrated for education purpose. Somebody was migrated by the Britishers as plantation laborers. Somebody migrated for some other professions because they thought that the future might be bright in some other countries rather than in India, which was ruled by the Britishers. Now, whatever may be the reason that they have migrated from India, but they have some ancestral origin with India. So for that particular reason, they would be considered to be person of Indian origin. Will they be eligible to become an Indian citizen at the commencement of the Constitution? Although they are not residing in India, in whichever country they are residing, yes, they are also eligible to become an Indian citizen at the commencement of the Constitution, provided first of all, they fall within the definition of person of Indian origin as per Article 8. So what is it saying? As per the Article 8 of the Constitution, who would be considered to be a person of Indian origin? Any person or his parents or his grandparents were born in undivided India but resides outside India. Say, let us assume a person who is in United States of America, a person X, let us assume, and where he is residing right now, he is residing in USA. That is at the commencement of the Constitution where he is residing in USA. But he is able to provide a proof that he was born in the territory of India. Where he was born? He was born in the territory of India as per the Government of India Act 1935. As per the Government of India Act 1935 means that is the territory of Pakistan, the territory of present India and the territory of Bangladesh. So all these things would be part of what is called as the territory of British India as per the Government of India Act 1935. So X is an individual assuming that in 1950, let us assume before 26 January 1950, he is staying in USA, but he was born in British India. So what if you want to become a citizen of India, will he be able to become a citizen of India at the commencement of the Constitution? That is on 26 January 1950, yes. For that, what he has to do? X has to go to the nearest Indian consulate in USA. That means he has to go to the nearest Indian embassy or its outpost or any of its offices, branches, anywhere in USA which is nearest to him, and he has to make an application to the concerned officer in that Indian embassy there that he wanted to become an Indian citizen. And if he makes his application, along with that he should also submit a proof that he is a person of Indian origin. That is, he himself is born in the territory of India, British India. If he is not born, at least his parents, if his not parents also not born, at least his grandparents were born in the territory of the Government of India Act 1935. Along with this proof, he also makes an application that he want to become an Indian citizen. Although he is not residing in India, he is residing outside India, but still he is eligible to become an Indian citizen at the commencement of the Constitution because he is a person of Indian origin. So what Article 8 is dealing with? Article 8 is not dealing with people who are residing in India at the commencement, but maybe outside India. But still, if they are a person of Indian origin, they can also, by following this particular procedure under Article 8, they can also become the citizen of India under Article 8 of the Constitution. To sum up what we have seen under Article 5, Article 6, Article 7 and Article 8, Article 5 talks about people who are domiciled in India. That's a primary criteria. Along with that, certain other criteria, if they fulfill that, at the commencement, they would be deemed to be the citizen of India. What is Article 6? Article 6 talks about those categories of people who have migrated from Pakistan to India. And depending upon the cutoff date, the procedure is different, but ultimately they are migrating from Pakistan to India, and at the commencement, they would be deemed to be the citizen. What is Article 7? Article 7 is about those categories of people who migrated from India to Pakistan and later again migrated from Pakistan to India. So they are also eligible to become the citizen of India at the commencement of the Constitution. Article 8 is about those categories of people who are living outside India, not even in India, but they are all person of Indian origin. Will they be eligible to become an Indian citizen? Yes. They will also be eligible to become an Indian citizen, provided that they have to prove that they are a person of Indian origin and make an application to the nearest Indian consulate in the respective country wherever they are staying. And they would also be eligible to become an Indian citizen at the commencement of the Constitution. So very, very important that you have an idea as to what is Article 5, 6, 7 and 8. In fact, if you see Article 5, 6, 7 and 8, these are the only 4 provisions which is given in the Constitution to decide as to who will be the citizen of India at the commencement of the Constitution. Apart from that, if a question arises, who are the citizen of India subsequent to the commencement of the Constitution, that is, somebody is born in India after 26 January 1950, the Constitution does not give any answer to that, or the Constitution does not provide any provisions for that. Rather, the Constitution is saying that subsequent to the commencement of the Constitution of India is empowering the Parliament, and the Parliament is the only authority to decide the question as to who would be the citizen of India subsequent to the commencement of the Constitution. And that power is given to the Parliament under Article 11 of the Constitution. So I would say Article 11 in the Constitution is one of the very important article which clearly specifies who is authority to determine the question of citizenship subsequent to the commencement of the Constitution. It is the Parliament. So in fact, our entire discussions with regard to citizenship is more about the law that is made by the Parliament under Article 11, which is nothing but the Citizenship Amendment Act. So we'll discuss about that. But before we go to that, we shall also understand couple of more articles, and then probably we will go to Article 11 of the Constitution. And then it would make better sense for us to discuss Article 11 and probably the Citizenship Act 1955 and the provisions under the Citizenship Act 1955. So now before that, let us try to understand as to what is Article 9 of the Constitution. Article 9 of the Constitution is making sure that no person shall be a citizen of India or deemed to be a citizen of India if they voluntarily acquired the citizenship of a foreign state. So this is very, very important. In fact, you might have heard that the Constitution does not allow for what is called as dual citizenship. In fact, today the law that is made by the Parliament, that is the Citizenship Act 1955, does not allow for dual citizenship, and even the Constitution also does not allow for what is called as dual citizenship. Now Article 5, Article 6, Article 7, Article 8, if you see all these categories of people, it all talks about people who would be deemed to be the citizen at the commencement of the Constitution. That means there are certain categories of people who would be automatically deemed to be the citizen at the commencement of the Constitution. Say for example, under Article 5 of the Constitution, that anybody who is domiciled in India, they would be automatically conferred to the citizen of India. Suppose let us assume a person X is domiciled in India under Article 5. So let us take Article 5. We are taking the example of Article 5. Suppose a particular person X is domiciled at the commencement of the Constitution, or he is satisfying the criteria under Article 5 of the Constitution. So therefore, he is conferred the citizenship. So he automatically becomes a citizenship of India. But what he does is, after he is conferred the citizenship, he also voluntarily acquires the citizenship of, say, let us assume, any other foreign country. Say, let us assume he acquires the citizenship of United Kingdom. So in that particular case, will he be able to continue as a citizen of India? No. Article 9 says any person who is a citizen of India or deemed to be a citizen of India, if he acquires a citizenship of some other country, then his citizenship is terminated. That means Article 9 of the Constitution ensures that even for those people who become the citizen of India at the commencement of the Constitution by virtue of Article 5, 6, 7 and 8, and if they take up the citizenship of some other country, then their Indian citizenship will be terminated. So Article 9 makes it very clear that the dual citizenship is not possible even for those categories of people who become or automatically considered to be the citizen of India at the commencement of the Constitution. Say, let us take another example. Say, we have taken the example of Article 8. Let us assume an individual Y. So this I am taking in case of Article 8. So this Article 8 talks about a person of Indian origin. Suppose let us assume a person who is a person of Indian origin but staying in USA at the commencement of the Constitution. So he goes to the nearest Indian consulate, makes an application that, and he also provides proof that he is a person of Indian origin, and he also makes an application to become an Indian citizen. So by virtue of Article 8, he is automatically deemed to be the citizen at the commencement of the Constitution, and Indian citizenship will be conferred upon him. Now, after the Indian citizenship is conferred upon him, few years later, let us assume, he takes up the citizenship of United States of America, because by law he is also eligible, let us assume, to take up the citizenship of United States of America. So the moment he takes up the citizenship of United States of America, the Indian citizenship will be terminated. So that is what Article 9 of the Constitution is making it very clear. So Article 9 of the Constitution is making it very clear that there cannot be what is called as dual citizenship. That is not permissible under the Constitution. And when you talk of dual citizenship today, for those people who become the citizen of India subsequent to the commencement of the Constitution, those are all dealt by the Citizenship Act 1955, which we will subsequently see. But Article 9 does not allow for what is called as dual citizenship. So that is not possible. So come to Article 10 of the Constitution. Again, Article 10 of the Constitution is very, very important for you to have this idea. Article 10 of the Constitution is making it very clear who is the authority to deprive your citizenship. So the authority to deprive your citizenship has been made very clear, and how at all your citizenship can be deprived, your citizenship can be taken away, is very, very clear by virtue of Article 10 of the Constitution. Now, two things that you have to understand under Article 10. One is Article 10 is giving certain element of stability for the citizens. As to once a citizenship is conferred, there is a certain element of stability. And the citizenship can also be deprived. So you should also understand under Article 10, once a citizenship is conferred, that doesn't mean that the citizenship cannot be deprived. But Article 10 is making it very clear who is the authority to deprive your citizenship. So let us read Article 10. Every person who is deemed to be the citizen or who shall continue to be the citizen of India, every person who is or is deemed to be a citizen of India shall continue to be such citizen subject to the provisions of any law made by the Parliament. That means Article 10 is making it very clear, either you become a citizen of India at the commencement of the Constitution by virtue of Article 5, 6, 7 and 8, or you become a citizen of India subsequent to the commencement of the Constitution by virtue of law that is made by the Parliament. In either case, your citizenship can be deprived only by a law that is made by the Parliament. So Article 10 is making it very clear who is the authority to take away your citizenship. It is the Parliament that is authority that can deprive your citizenship. And we know what is the power of the Parliament. Of course, the power of the Parliament is to make a law. That means the government or the executives cannot unilaterally take away citizenship unless and until a law authorizes the executives to do that. So the power to deprive the citizenship is only in the hands of the legislature. To be very specific here, it is none other than the Parliament of India. So that is what Article 11 is saying. So Article 10 is saying, so Article 10 is giving some guarantee that once you are given the citizenship, you can continue to be the citizen. But again, the concept of citizen is not permanent. How it can be taken away? It can be taken by the law that is made by the parliament. So the authority to take away citizenship is provided in Article 10 of the Constitution. And who is authority? That is the parliament. But however, if you see Article 11 of the Constitution, Article 11 of the Constitution is going beyond that, while Article 10 is fixing the authority, and the authority is parliament. But whereas Article 11 is empowering that particular authority to make law as it wishes to deal with the concept of what is called as citizenship. And that is what is Article 11. So what is Article 11 is saying? Article 11 of the Constitution is saying that the parliament shall have the power to make any provisions with respect to acquisition and termination of citizenship and all other matters related to citizenship. So Article 11 is making it very clear that the Constitution of India is giving power to the parliament to make any law as it wishes to deal with what is called as acquisition of citizenship, that is subsequent to the commencement of the Constitution. If somebody is to acquire the citizenship, how they can acquire the citizenship? The parliament can make a law. And to that extent, we are giving the power to the parliament. Not only for acquisition of citizenship, but also for termination of citizenship. That means if somebody citizenship is to be taken away, for which also you can make the law, and as you wish you can make the law. So it is for depriving the citizenship of someone who become the citizen at the commencement or subsequent to the commencement. In both the cases, their citizenship can be deprived by a way of a law that is made by the parliament. So that is also made clear under Article 11. Not only related to acquisition and termination of citizenship, any other matters related to citizenship. So who is having the power to make the law? It is the parliament by virtue of Article 11 of the Constitution. And by the virtue of the power that conferred upon them, the parliament enacted what is called as the Citizenship Act 1955. And today the Citizenship Act 1955 deals with number of ways by which the citizenship can be acquired subsequent to the commencement of the Constitution. Say for example, the citizenship by way of birth, descent, so on and so forth. There are a number of ways which we'll subsequently discuss in the next class. This act not only deals with how the citizenship can be acquired, but also how the citizenship can be taken away. In fact, the Citizenship Act 1955 provides 3 ways by which the citizenship can be taken away by the state. Citizenship by renunciation, citizenship by deprivation, and citizenship by termination. So what are these grounds? What are the ways citizenship can be acquired? What are the ways citizenship can be taken away? So we'll discuss that in our coming lecture. So in the next lecture, I'm going to elaborately discuss about the provisions of the Citizenship Act 1955. So basically there we'll try to understand what are the grounds on which the citizenship can be acquired and how it can be taken away, including how the citizenship can be terminated or deprived. So we'll try to understand that elaborately in the next class. So before I complete this particular lecture, so I'll just take a couple of minutes to quickly revise what we have seen. So if you look into the citizenship, citizenship is what? Citizenship is nothing but a legal status conferred upon the state, conferred upon its citizens, so that it empowers them with full civil and political rights. Now, does the alien have any rights? Yes, they may also exercise the rights, but not full civil and political rights as that of the citizens. And if you look into the Constitution deals with 2 types of categories. One is that who are deemed to be the citizen at the commencement and who can acquire the citizenship subsequent to the commencement of the Constitution. And who are all deemed to be the citizen under the Constitution? Whoever satisfies the condition under Article 5 or 6 or 7 or Article 8. Article 5 talks about people who are domiciled in India at the commencement. Article 6 talks about people who migrated from Pakistan to India. Article 7 talks about people who migrated from India to Pakistan and later from Pakistan to India. Article 8 talks about people who are person of Indian origin staying outside India at the commencement. So people who may satisfy any of these conditions, they may become the Indian citizen at the commencement of the Constitution. And apart from that, what is Article 9 is saying? Article 9 is saying that even though you are deemed to be the citizen at the commencement of the Constitution, but if you have taken up the citizenship of some other country, your Indian citizenship will be terminated. That means there is no concept of dual citizenship. Article 10 is saying that once a citizenship is conferred upon anyone, who is authority to deprive the citizenship? The authority is only the parliament. No other authority can deprive the citizenship. That is only by a way of a law made by the parliament it can be done. Article 11 is giving the power to the parliament to make law as it wishes as to how the citizenship can be acquired subsequent to the commencement of the constitution, and also how the citizenship can be deprived, and also any other matter related to citizenship, and by virtue of which the parliament has enacted what is called as the Citizenship Act 1955. Alright. So tomorrow in the class we'll try to understand, in the next lecture we'll try to understand as to what are all the ways by which the citizenship can be acquired subsequent to the commencement of the constitution, and also what are the ways by which the citizenship can be lost. Very, very important lecture. So just go through the particular question. If you watch my lecture very carefully, I'm quite sure that you will be easily answer this particular question. So look into the question. Consider the following statements. The citizen shall exercise all the civil and political rights in our country. Is it right or wrong? Aliens shall not exercise any rights in our country. So statement 3, the right to vote in elections in India is only the right of the citizens. How many of the statements given above are incorrect? So among the 3 statements, how many are incorrect? So you can put your answers in the comment box. And if you have any questions related to the civil service examination, you can reach out to me. You can reach out to me either through my Telegram channel or through my Instagram account. And if you have any of your friends or family members preparing for UPSC examination or any of the other competitive examination, you can refer them this particular channel, and I'm quite sure that this particular series will be immensely beneficial to all the students preparing for various competitive examinations. So thank you very much. Keep watching. All the best.